The following program does not have a normal intro because I was really too busy smoothing other things over to get it done. So, Ori, good evening, everybody. Welcome to the following program. I am your host, Joe Neerman, aka Good Logic. I apologize for my delay. I was dealing with all sorts of physical, technical, just one relatively small issue, but each of them requiring like a couple minutes to sort out. So I apologize for that. Let's get it started. So a lot of you might not be aware just how hard this fight is going in the New York case over Trump's free speech rights. And this is something we've seen in several cases. We see it in Washington, D.C. and in Georgia, that this issue of freedom of speech seems to be something that what we would think, and most of us would like, hope, and expect would be unfettered, certainly seems to be rather fettered. It's rather fettermaned. Freedom of speech is no longer unfettered. It's rather fettermaned. It's fettered. It's as fettered as you can imagine. It's pretty fettered. Pretty fettered. So what I wanted to do is I'm going to be going through the legal documents, but I also want to have a discussion with you. And I want to look at the other side of the coin. I really want to fairly assess. Well, obviously, I lean as close as possible toward being a free speech absolutist. In practice, on my channel, pretty much anything that's going to not destroy the chat, I'm okay with it. Even if it's something that I think is stupid and annoying, but I think spam destroys chat. I think racism destroys chat or violent terms of service. But basically, the only limitations I have in speech in my channel, essentially, are don't screw up the chat. You can say whatever stupidity you want to say, but don't make things screwed up. Because I think that that's abusing the privilege of freedom of speech. That's as limited as that's as small a limitation on freedom of speech as I can possibly come up with, because I lean toward being a free speech absolutist. That doesn't mean, though, that there is not, let's say, theoretically, alternative perspectives on free speech that, even if I disagree with them, may merit analysis as to, okay, I disagree with you. That's your opinion. That's my opinion. Why is my opinion right and yours wrong? And I think that's an important discussion. And I want to have that discussion with you before I close out tonight. But I want to start with this. It's actually a clip of Elon Musk, where I think he actually, it's an interesting thing. You would think that the wealthiest man on the planet would never have freedom of speech issues, but here's a clip from an interview that he had, which makes you realize that that's not really completely true. Even the wealthiest on the globe, perhaps wealthiest in human history, perhaps, even he has sacrifices that he needs to consider if he really wants to engage in free speech. And this is a great clip, such a great clip.
God, no. I don't want to at all. But what I'm trying, even came up though in the annual meeting. I mean, do your tweets hurt the company? Are there Tesla owners who say, I don't agree with his political position and I know it because he shares so much of it? Or are there advertisers on Twitter that Linda Yaccarino will come and say, you got to stop, man. Or, I can't get these ads because of some of the things you tweet.
Look how long he pauses. He's like really thinking about this. It's crazy. I mean, look at how long the guy pauses. Look at that pause. He's asked a question and just like watch the timer. It's at 34 before he answers. How long is he sitting there? He's asked a question. Aren't you, do people come to you and basically complain that your tweeting is hurting their bottom line? They don't like you. You're hurting sales. You're hurting sales. Dennis Petit is not hurting sales. Welcome back, my friend. It's been way too long since I've seen you. Good to see you, my brother. Remember the following. Yeah, look at how lengthy this pause is, where you could see he's genuinely reflecting on the question. This is something he's obviously considered before, but he's trying to figure out how he wants to answer, as you'll see from his answer.
I can't get these ads because of some of the things you tweet.
23, more than 10 seconds.
You know, I'm reminded of there's a scene in The Princess Bride. Great movie.
Great movie.
Where he confronts the person who killed his father. And he says, offer me money. Offer me power. I don't care.
So you just don't care. You want to share what you have to say.
I'll say what I want to say, and if the consequence of that is losing money, so be it.
Okay.
There you go. There you go. He's like, I don't care. I don't care. Because freedom of speech is everything. It really is. Now, I guess you can say that to a guy like he's someone who actually could afford to like just, close Tesla and it wouldn't bother him at all. But maybe he is such, as they say, just burn money. That's not how they say it, but that's how I'm going to say it on this show because it's a family show. Yeah, that's what are you going to take from him already? Anticipation, making me wait. I bought Tesla because of his tweets. Yeah, he's great. Yeah, his tweets are great. I know that he got in hot water for some of his tweets of late, but I really think that was taken out of context. I think I mentioned briefly on our show here. I think that's some of those comments. People just really reacted way too quickly and too. I actually even had to tell family members. I was like, he doesn't hate the Jews. That's the media that's trying to convince you he hates his Jews. He's not going around saying you're harboring enemies of the state under your floorboards, aren't you? That's not what Elon's doing. Don't worry. He's not going to come knocking on your door asking you for a glass of milk. It's not happening. Don't worry. Elon's safe. He's safe, at least for now. But that's the media that wants to portray him that way because that's what they want to do. That's just what they do. All right. So that's why, but the point that I'm making here is we're seeing two of the most powerful people on earth fight for their right for free speech or their ability to express themselves. This is astonishing. I mean, it's crazy. That's crazy. That's pretty much it. That's pretty much it. Yeah, it doesn't. Yeah, Jews buy Teslas too. Okay. I don't think he cares about any. I really think he doesn't care. Look how long he sat there, just sort of like, how do I want to express this? Because I really don't care. Like, go ahead, offer me money. Tell me how much you. Tell me like this. Like, I think he sort of gets it that it's like. There's no money you're going to give me that's going to improve my life. So he's sort of working outside the metric that the rest of us are working in. It's like if you gave him another 5 billion, 20 billion, 100 billion, trillion, how is that affecting his life at all? Like at all? Like what would he be able to buy with that he cannot now currently buy? I mean, it's like at a certain point, what is money? It doesn't have any value to him anymore. So, anyway, but I wanted to get into this free speech. So, in the First Circuit, there's an appeal going on about a gag order that was issued by Judge Engoron in the New York civil case that the AG brought against him, trying to go fine him for $250 million for his purported fraud. Now, Today, Trump filed his reply. He lost his motion to have the gag lifted, appealed, and now when you file the appeal, so there basically was an offering that's initially made by him, Trump, petitioner. Then there's a response that comes from the AG's office, and then he has an opportunity to reply. So basically, the opposition comes in between the initial firing and then a reply. That's the way we do things here in New York and probably in most jurisdictions. There's no tracksuits. There's no and it's not my cult. It's not. I'm not the leader of the following. I happen to be a member of the following. I am not the leader of the following. The following is just it's not a culty type of cult. I'm not a leader of the following. There's no tracksuits. There's no Kool-Aid. There's no self-harm. No self-mutilation. No harming others. No squirrel hangings. No animal sacrifices, no smearing blood on different parts of your body or anything like that, no self-harm, no walkie-talkies, very limited use of farming equipment. You'll be happy here. You're gonna be happy. You'll be very happy here, Dennis. Anyhow, let's get into I want to get into this motion. And I'm actually going to start by showing you the opposition. I first want to go through the opposition to the motion. Because and this is the opposition to the appeal. This is in the appellate court. So this is the first department. When in New York, our nomenclature is the trial court level we call Supreme Court. It's Supreme Court in that we consider the court of original jurisdiction. I know that doesn't mean anything to you because when I was a first year law student and I was interning at a firm, and they called it the court of original jurisdiction. I didn't know what that meant, so I'm sure very few of you who are now attorneys know what that means. But basically what that means is that's a court you can go in and deal with any issue as opposed to other courts which are limited. It's supposed to be a $25,000 minimum. And if it's $25,000 minimum, you can go in there and you can get plenary relief or you can get equitable relief. That's why they call it the Supreme Court. Equitable relief is something you can only get in the Supreme Court. You can't get that in any of the lower courts. And that's equitable relief is basically, think common law type of fairness, where you're seeking fairness. That's what we talk about, equitable relief, as opposed to dollars. Now, also, if it's a sufficient number of dollars, meaning $25,000 or above, you go to the Supreme Court. That's the trial court level. There are 3 levels. The level above that, the second highest level, that's the third level, the tertiary level. The secondary level from the highest is the appellate division, which is broken into 4 departments in New York. And so every county, there's 62 counties in New York, every county has its own Supreme Court. Those counties are all sectioned into different departments, one of 4 departments. So there are 2 departments. The first and second department are dedicated to the city and surrounding area of New York. So the city and Long Island are all part of the first and second department. New York County, which is where Manhattan is, which is where this case is going on, is part of the first department. So this was filed in Judge Engeron's boss, which is first appellate, which is New York Appellate Court, first department. I should let you see what we're looking at here. First department. From here, you can appeal here as of right. You don't need approval to go to the appellate court, but you cannot just go as of right to the New York Court of Appeals, which is only one New York Court of Appeals. That is the highest court in the state of New York, and they just issued such a lousy decision with respect to the rights of with the issue. They raised issues of standing not related to this. They issued a lousy decision, which basically said that Governor Hochul can basically issue whatever mandates she wants because this fight, which was won at the lower court, petitioners didn't have standing, which is the lamest way of knocking a case out. I really thought about spending the entire night talking about that case. Thought long and hard about talking about that case. But I was like, this is going to aggravate me. It's going to aggravate me. And it's also too technical. So I just wasn't in the mood for it. All right, let's get into it. So I think it's good to start. I want to start with the opposition because all of us agree free speech. Most people, I think, watch me agree with concepts of free speech. By the way, I am right now streaming not just on YouTube over here, but also on my Good Lawgic channel, but also on Trump Trial. So if you wanted to watch me there, you can catch me over there. And obviously also on Rumble. So, hey, Rumble people. Okay. So this is an affirmation opposition to the motion for a stay. What he was looking for was a stay. They didn't just file an appeal, but they said, we want to have a stay on the gag order. So what you can do when you file for an appeal is you say this ruling of a gag order is improper. And I know it's going to take the appellate department, it's going to take the first department a while to decide whether or not this is improper. But in the interim, we are asking the court to apply a stay and say that while you're mulling this over, in the meanwhile, the gag order should not be in effect. When you're looking for a stay, it's a form of it's like getting what we call a temporary restraining order, or pendent lite in Latin, which is basically it's relief pendent lite, which is or some people pronounce it lita because it's spelled L-I-T-E, but basically pending litigation, which basically means this is the relief. This is the rules that I want to set up. I want to get a restraining order. I want to say this order, which is gagging me, this order, this gag, this muzzle is restrained from going on my mouth. It's a little confusing. I understand that the way things flip around from a technical perspective, but we're going to see here that even though in the underlying case, Trump is the respondent and the AG is the petitioner, because he's the one appealing from this case. Over here, Trump becomes the petitioner, and Judge Engoron and Letitia James end up becoming the respondents. Now, I'm just walking you through the technical elements here. So for purposes of this appeal, it gets its own index number when it goes to the appellate court. This is a different index number than what they're using in Supreme Court. It gets its own unique index number when it goes up to the appellate department that they assign to it, and that's how the first department will recognize it and keep track of this case. When you file it under, as if it's a completely different case, and it is. And what he's basically doing is he's going to the court and he's saying there's an order that I want enjoined, I want it stopped, I want it put on hold. That order is designed to muzzle me, to serve as a gag on me. So I think that order is wrong. I want to appeal that order and have you overturn it. Now, it's going to take you a long time to decide this. I had an appeal before the first department, okay? Was it first department? I think it was first department. Second department? Nope, sorry, second department. But there's really very little difference. I had appealed for the second department that I waited 3 years for a decision on. 3 years before I got to go up there for oral arguments. And like a month after I went for oral arguments, the court's like, oh yeah, you totally win on this case. It was like a slam dunk that I should win. It was not that hard an appeal because I thought that the judge at the lower court really came to a bafflingly improper decision. We'll just phrase it that way. So with that being the case, my point is the timing on this, it could be 3 years before the appellate department, the appellate division actually issues a decision on this. So the only thing that's actually really going to matter here is this TRO, because you're basically saying while you're deciding whether or not under New York law Judge Engoron got it right and issuing a final decision, is this muzzle going to be going to effect, or can I restrain that muzzle, get a temporary restraining order and saying while this isn't before the appellate court, that muzzle is restrained, and then ultimately if I lose, then that muzzle clamps onto me. That's what, so really this is a motion in the appeal, and this motion is for purposes of this particular appeal is really everything as far as Trump is concerned. Because if the first department comes back 2.5 years from now and says, oh yeah, you know what, we think Judge Engoron was wrong when he issued it, so now when he issued that order gagging Trump, that doesn't help him anymore because the case will be over, and once the case is over, the gag is gone anyway. It's really becomes, the whole issue is moot, and the word is moot, not mute. Just making that point. Pet peeve of mine. Okay, so now we're basically arguing about should there be a restraint stopping the muzzle that Judge Engoron wants to clamp over Trump's mouth. In order to obtain a temporary restraining order in New York, you need to establish 3 things. So you need to show a likelihood of success on the merits. You need to, which means that there's a really good chance you're going to win. You need to show balancing equities, which means justice justice demands that it's more just to look at it this way, to err in my favor than it is to, and if you were wrong, it's just in the interim, it's just more just for that to happen. And you need to show irreparable harm. Irreparable harm means something that if you there's no money, there's no amount of dollars that can fix this. If I don't get this, if I'm wronged and I don't get the relief I'm seeking, I will be irreparably harmed. What does that mean, irreparably harmed? It means there's no compensation, no amount of dollars that anyone could ever give to me that would make me whole again. And when it comes to freedom of speech issues, that's clearly true. I mean, how would you possibly figure out how would anyone come up with an accurate number to figure out how much Trump was damaged by a wrongful gag that's issued by Judge Engoron? I think even the Attorney General would recognize that to the extent that they're arguing about these 3 elements, that's not an element they're going to be arguing on. It's likely that in the opposition papers, they're going to argue about likelihood of success and possibly balancing of equities. So I'm going to say, hey, he doesn't really win. It's not a great chance he's going to win ultimately. And part of that is balancing of equities, meaning they're going to say, if we allow him to speak, there's so much terribleness that could come out of this, so many bad things that can come out of this, that justice demands that you deny this TRO. And the court, if they find the balancing of equities favors the AG's position, the TRO has to lose. That's just the way the law works in New York. So if you're the Attorney General, what I anticipate, and I have not gone through this affirmation opposition. Affirmation is basically a declaration, a statement that's signed off by an attorney. When we have an attorney sign off on it, it's called an affirmation. If it's anyone but an attorney who signs off on it, it's called an affidavit. Which basically, so I expect them to be focusing in their affirmation opposition on balancing of equities, being like, there's a calamity that's going to come if Trump is allowed to speak, and also on the lack of likelihood of success on the merits. But when it comes to the issue of irreparable harm, I don't think they're going to argue very much on that, because on that factor, that if he's wrongfully enjoined, the harm to him would be irreparable, that's the weakest area for the AG. Dennis Fan, an attorney admitted to practice law in the state of New York, who is not a party to his action on the penalty of perjury, affirms as follows: I am a senior assistant solicitor general in the office of Letitia James, Attorney General of the state of New York, the OAG, the plaintiff, the underlying executive law enforcement action from which the CPLR Article 78 petition arose. So the petition seeks a writ of prohibition against respondents. The Honorable Arthur F. Engoron, Justice of the Supreme Court in New York County, who's presiding over the ongoing trial in the executive law action brought by the OAG against petitioners and OAG. I submit this affirmation in opposition to the motion by petitioners, entities operating as the Trump Organization and certain executives of the Trump Organization for a stay of 4 orders of Supreme Court dated October 3rd, 2026, and November 3rd, while this court resolves the petition challenging those orders. So in other words, I'm here to try and knock out the TRO. I'm familiar with the facts and circumstances of this matter based upon my review of the relevant orders and decisions rendered and submissions filed by the parties in this action and through communications with other OAG attorneys. You always have to put in your affirmation. This is a classic second paragraph. This is something they can merge into 2, but basically 1 and 2 into 1. But you always start off by spelling out who you are and what your basis of your knowledge is. Whenever you have any affirmation or affidavit in New York, you have to, this is ultimately made under oath. At the bottom, I'm sure I haven't looked at it, but I'm positive at the bottom it says sworn to before me this day, or I hereby affirm on the penalties of perjury. Actually, is how he would say it, because it's an affirmation. So you're self-affirming, but it's made under oath. And he says, Supreme Court issued 4 orders challenged here today to protect the safety of the court staff and to ensure the orderly progression of trial proceedings. The court issued the orders in response to the extraordinary and dangerous personal attacks made against the court's staff by both Petitioner Donald J. Trump and Petitioner's counsel during the ongoing trial. Specifically, Petitioner and the counsel repeatedly made baseless, highly inappropriate, and personally identifying attacks against the court's principal law clerk. This is Ms. Greenfield. We can shorten that. Greenfield is a long name, so we'll just call her GF. Despite multiple warnings from the court, those attacks continued. Supreme Court's October 3rd, November 3rd orders properly prohibited petitioners and the counsel, respectively, from continuing to target the court staff. Why? Okay, explain to us why. The court issued its October 3rd order, which prohibits the parties from publicly commenting about the court staff after Mr. Trump posted on social media and emailed to millions of recipients a personally identifying and disparaging comment about the court's principal law clerk. How is this not freedom of speech? Okay, maybe walk us through it. The court issued its November 3rd order, which prohibits the parties' counsel from commenting on the principal law clerk's communications with the court after petitioner's counsel refused to stop repeating unprofessional and vexatious arguments about the fact that the principal law clerk communicates with and advises the court, which is a significant part of her job. Now, what they're talking about here is this. What they're addressing here is that there is a very unusual, what they're saying is part of her job, part of Ms. Greenfield's job, is a bizarre way of framing this. This is practically gaslighting, which I expect that the appellate court likely is aware of the situation only because this case has been so nationally heralded. The way they position themselves is unlike any court I have set foot in New York, to my recollection, where you have a judge with his clerk sitting equal height with him, right next to him throughout the trial. And the effect is, when you walk in there, they look like a king and queen who are sitting over you. Now, there's only one duly elected judge, and that's Judge Engeron. She ain't no judge. So even by the way that the court is set up, forgetting anything else, it's a very disconcerting thing because you sort of ask yourself, who is this person here who every time he issues an order or he makes a ruling, he seems to look at her it's like he's got like what's that character's name, like Worm Tongue, like who's basically like whispering. it's like all of a sudden you need Gandalf in there. It's like free the judge from this clerk who's like, we don't like him, send him away. That's basically what it feels like when he like looks over. What should I do? Like you gotta like pull out you're this mighty thing and just be like, I release you. That's what you feel like you have to do. I don't know. Maybe we release him. Maybe release him from this. Maybe like all of a sudden we'll see like he's actually like 35 years old and like his hair will be like this healthy flowing thing, and all the warts and weird stuff will just sort of melt away from him. It will banish Worm Tongue away from. I don't know. Maybe it's. I don't know if that's true. I don't know for sure that that's true. But yeah. So that's part of the issues they have here is the way he's conducting his court. So Trump has been talking about this on Truth Social, and Engeron is like, no, you can't talk about that. Why can't he talk about that? What is the? All right. Each of these orders properly imposed exceedingly limited restraints on speech to protect the safety of court staff and preserve the orderly administration of the trial. Accordingly, petitioners' free speech arguments are meritless. Meritless is kind of weak, and the equities tip decisively against the state. See, balancing the equities. I told you that's where they're going to go. They want to say, I want you to balance look at the equities as being justice demands you agree with us. We have to protect his staff. Protect his staff. As courts have repeatedly made clear, neither litigants in the council nor the counsel have an unfettered right to say whatever they want. See? Very fettered right. This is where we started. Very fettered right. Trial courts may impose reasonable limits to further important interests such as protecting court safety. You knew they were going to go there. Otherwise, the trial could be derailed by ad hominem attacks. Well, the whole trial is going to go off the rails. Supreme Court Order 20. So that was all addressing October 3rd and November 3rd orders. So that's the basis for them saying that's the justification. And like I said, I told you they were going to lean on the equities because I know that's essentially what Judge Engoron rooted his whole thing in. Like, I have to save my staff. I have to save my staff from being embarrassed on social media by Trump and his millions of followers. Now, there's two other orders. The Supreme Court's October 20 and 26 orders properly sanctioned Mr. Trump $5,000 and $10,000, respectively, for violating the court order for the October 3rd order. The court issued its October 20th order after Trump continued to publish on his presidential campaign website the derogatory post about the court's principal law clerk, despite the court's order prohibiting such statements. Court issued its October 26th order after Trump made another inappropriate comment about the principal law clerk, accusing her of being a partisan actor at trial to reporters located immediately outside the courtroom. This is just astonishing. It's crazy. It's really crazy. Court should deny petitioner's motion to stay. Moreover, there'll be no irreparable harm. Oh, they actually went to the irreparable harm. There'll be no irreparable harm. Now, Trump has to win on all three of these elements in order to get his TRO. Likelihood of success on the merits. Balancing of equities favors him, and irreparable harm. So I didn't expect them to argue much about irreparable harm. Let's see what they're saying about that. I guess they're saying when it comes, moreover, there'll be no irreparable harm to Mr. Trump absent the state because he'll get the monetary amounts back if he ultimately prevails in the underlying petition. Yeah, I agree with them on this. That's a fair point. With respect to the October 20 and 26 orders, I don't think there's irreparable harm. Again, I just want to point out to you, so there's 4 orders that are being appealed here. 4. There's an October 3rd and November 3rd orders. Those orders relate to the things that Trump is prohibited from saying. Those are the actual gags. Then you have the October 20 and October 26 orders. That's an order saying you owe $5,000 and another order saying you owe $10,000. So he's appealing all 4 of those orders, but the only ones that really relate to the ongoing gag are the orders that were issued on October 3rd and November 3rd, respectively. So in order to get a TRO for any order that he wants to not have come into effect, he has to show all 3 of those factors. Those 3 factors again are likelihood of success on the merit, balancing equities, irreparable harm. Irreparable harm, it's never considered irreparable harm if money can fix the problem. So 2 of the 4 orders just relate to how much money he has to pay, and he's already paid the money. So he doesn't need to get a stay on that. That's not going to hurt him at all. That's the point. And I think that's a fair point. And I think he's going to lose. I think he's going to lose the TRO on these 2 orders because of that lack of irreparable harm. And you need to have all 3 elements in order to get your TRO. That doesn't mean he might not ultimately prevail and get his money back if and when the court recognizes that Judge Engoron's orders, specifically his order dated October 3rd and the other one dated November 3rd, are unlawful. So once it's unlawful, so when they decide this 2 years from now, so if they actually come to that conclusion, they'll be like, since it's unlawful, we're also overturning the money that he had to pay and giving that money back to him. But as far as him getting it now on a TRO, he doesn't need the money back on TRO. Finally, petitioner's arguments about contempt fail because the court did not hold Mr. Trump in contempt. Rather, the court properly imposed sanctions for frivolous conduct under the rules of the chief administrator. So they're trying to get ticky-tacky here because they know that this is something they recognize, that higher level courts in certain states love to focus on procedural elements if the mood strikes for whatever reason. Now, I practice law in this state of New York, and I would never disparage anybody. And I hold the New York judiciary in the highest esteem. But I've spoken on this channel many times about how a judge can make a ruling if they're so inclined, if they can find procedural bases often. Not always, but very, very frequently. So what he's trying to say is there's a procedural element that you might want to hang your hat on here if you want to find in our favor, Your Honors. Your Honors. A single justice court issued an interim stay of Supreme Court's 4 orders. The return date for that motion is November 27th. OAG urges court to deny the motion as soon as possible. So the return date for when this motion is supposed to come, when are we going to come back here? Well, that's today. So we're asking you to please deny this motion quickly and prior to the completion of trial, which will conclude on around December 8th, absent rebuttal witnesses. A speedy denial is necessary to ensure the safety of the Supreme Court staff and the integrity and the orderly administration of proceedings. In September 2022, the OAG brought in action. So now they're going to go through the history here and why it is that they think that they're right. In September 2022, OAG brought in action Supreme Court against petitioners, blah, blah, blah. Bench trial in the action has been ongoing since October 2nd. OAG completed its case in chief on November 8th. Petitioners are currently presenting their case in chief. That's where we're at now. High-profile nature of this trial has required extensive security preparations by the Supreme Court. It's been a nightmare trying to take care of a security. It really is a little bit of a hassle. It's been a hassle. I mean, having a president come to court every day, or, it's been a hassle. The parties and counsel since the start of the trial, this court has been inundated with hundreds of harassing and threatening phone calls, voicemails, emails, letters, and packages. Exhibit J, November 3rd, order at 2. We attach that? Let's check out the document list here. Where's your Exhibit J? That's all deleted. I can't see that. I can't see that. This is the court's file. This is the things that are uploaded to the court. Not a lot of filings. This is its own process. This is its own number. This is just for the appeal. Okay. So for the appeal, it starts with the notice petition with supporting documents, including exhibits and application for interim relief and supporting documents. This over here is where you have the filing of the opposition motion. This is actually the corrected one, which is the one I should be reading. I'm reading the uncorrected one. Whoops. It should be the same thing though, right? Oh, this is a different one? Oh, God, I'm not reading both of these. The second affirmation? I'm not pulling that up. I hope that fan got everything right the first time. And then over here, we had today the affirmation in reply that was filed by Trump's counsel. He's referencing here different exhibits. Normally the exhibits you would think would be filed. I'm not seeing them. The court issued the challenge orders to protect the safety of its staff during the trial and to ensure the orderly administration of trial. It's poorly worded, but that's what it says. Supreme Court issues its order October 3rd against petitioner Donald Trump and other petitioners to protect the court staff. From the October 2 start of the trial, petitioners' counsel began personally targeting Supreme Court's principal law clerks. So they're saying it's not simply Trump, but his lawyers. His lawyers are bad people. We don't like his lawyers. His counsel, his attorneys are personally targeting the Supreme Court's principal law clerk in a highly unprofessional, inappropriate manner. For example, during her opening statement, one of the petitioner's counsel, which has to be Alina Habba because she's the only woman there, improperly commented about the principal law clerk by openly complaining that she's probably writing the court a note right now to say the counsel's arguments were inaccurate. And she's probably writing to you something right now claiming that I'm inaccurate. That's pretty funny. Girl got some backbone on her. She got some backbone. That day, yeah, deleted means that someone withdrew it. I don't know. You see what I see. I see a whole bunch of deleteds also. I got no idea what was there. This is what we see. So I don't know what that is. Yeah, I thought I was curious too. That day, during a break from trial, Mr. Trump announced outside the courtroom door in front of the news cameras, this rogue judge, Trump hater, only one that hates Trump more is his associate up there, the person who works with him, and she's screaming into his ear on almost every time we ask a question. It's a disgrace. Live now from New York, Trump trial video. Trump blasts rogue judge during break. The court then gave petitioners an off-the-record warning. Oh, do they have a link here? Does this link work? Does that work?
Following here for you is the former President Donald Trump in a New York City courthouse there, and continuing to be making remarks throughout the day. Here's just some of his remarks.
Case where banks got paid a fortune, loaned money, got paid money back, didn't even need their money. We built a great company, and we have to go through this. So this just broke, but before I discuss that, why are we trying a case that the Appellate Division of New York State...
In case you're confused, this is a link that was included in the opposition motion to this application for a TRO that was filed in the First Department. And they're saying this is the video, which is why the gag order was issued. Look at how terrible he is. Look at these awful statements he says here. This is what precipitated the issuance of the order.
Has just ruled recently that we won 80% of our case. And this judge refuses to acknowledge the ruling, which is very plain for all to see. We won, as you know. It had to do with Ivanka, and it had to do with other things. It had to do with the statute of limitations, where they wanted to go back to 200 years ago, 500 years ago. It was limited, very much limited, and it amounted to about 80% of the case was won by us in the Appellate Division. And this rogue judge, a Trump hater, the only one that hates Trump more is his associate up there, his person that works with him. And she's screaming into his ear on almost every time we ask a question. It's a disgrace. You want to know the truth? It's a disgrace. So this rogue judge refuses to acknowledge the fact that we won 80% of this case in the Appellate Division, including statute of limitations. You know, in the statute of limitations.
So that's the part where he referenced Greenfield. So we're going to stop there. But that's basically that's what got the judge to issue the order. Kimmy says you should play Trump's new truth from 1 hour ago. It's a video about Greenfield. More fines coming. Oh, really? I'm going to pull that up. Definitely want to pull that up. Definitely want to pull that up. Thank you, Kimmy, for sharing that. The only reason anyone's on Truth Social.
Judging.
Which one? All right, we're going to pause here and try and figure out which video. I don't think it's this one. I don't think it's this one. It's a little loud. Maybe it's this one. I'm getting goosebumps. I'm getting goosebumps.
Run, boy, run. This world is not meant for you. Run, boy, run.
Yeah, that's going to get me a copyright strike right there. I don't know that song, but now I wanna. Now I wanna. I don't think it's this one. It's probably this one.
Judge Engoron should be ashamed of himself for letting this highly partisan Trump hater to be involved in this case that should have never been allowed to start, but should have been ended immediately. And this is just the beginning on her and the judge. She sits next to him at trial, unheard of, and tells him every decision to make. She hates President Trump, one of our greatest presidents in history, and is doing whatever is necessary to become a judge, including giving $3,600 worth of illegal campaign contributions to Democrat clubs. No way this case should be allowed to continue.
Now, just to be clear, Judge Engoron claims they're not illegal because since she's running for political office, she's allowed to give more than the normal minimum under New York law. So he claims that they're not illegal. Now, how he knows that, I don't know. There's no sworn affidavit submitted to suggest that, but apparently he knows it.
President Trump's values were conservative. The judge's values were fraudulent, where he said Mar-a-Lago was worth $18 million when it's worth 50 to 100 times that amount. Likewise, Doral and other properties. Judge Engoron should dismiss this case immediately because it's leading to big problems for New York and him. He is a servant to the corrupt Attorney General of New York State, Letitia James. They fed him false information.
Look at how they sit.
He called President Trump.
Isn't that crazy?
Letitia James.
It's the weirdest thing in the world. It's so weird.
False information based upon which he called President Trump a fraud. He and the Attorney General are the frauds for putting out false stories and for her campaigning that she will get President Trump.
In the heart of a Letitia James campaign event, one individual stands out. Hobo Judge Arthur Engeron's principal law clerk, Allison Greenfield, is in the front row taking pictures as the candidates bash President Trump. Greenfield's voice is audible, conveying criticism towards President Trump and his supporters.
You're asking an interesting question, Kimmy, because it doesn't seem like he's saying it. He's just sharing a clip about it.
This is the most important election ever. It's true.
That's right.
We are engaged in an epic, maybe even generational fight against an anti-democratic movement, a dangerous anti-democratic movement which has taken over one of the major parties of this country. You're going to become a judge just because of that. I mean, right on.
Oh, they're on the wrong
In June
side.
2022, while the People versus Trump case was ongoing, Greenfield was observed actively campaigning with Congressman Jerry Nadler. As chair of the House Judiciary Committee, Nadler led the impeachment of President Trump. In 2022, Greenfield was also spotted engaging in campaign activities for Alvin Bragg. In a quote, she expressed her general support for Alvin Bragg's policies.
I am generally very supportive of Alvin Bragg's policies.
In June 2022, during the pendency of the People versus Trump case, videos depict Greenfield's presence at a political rally supporting Letitia James. Greenfield can be seen seated with a clipboard filled with signatures, actively involved in petitioning and campaigning for Letitia James. Is Greenfield passing instructions and directives from Letitia James, Jerry Nadler, and Chuck Schumer to hobo judge and corrupt Democrats?
I'll tell you this much. It's very, very disconcerting. The appearance of a lack of integrity. When you have Letitia James, when she's sitting there campaigning, think about this. I mean, let's just put Trump aside for a second. But basically, you have one person who's sitting here killing herself campaigning for this individual to be the attorney general. And now this individual is sitting in courts day after day, asking a judge who's supposed to be neutral to punish X. And this guy's taking counsel every 2 seconds from a woman who's actively campaigning for her. I mean, it's ridiculous. It's ridiculous. And especially when you know that she was campaigning on a basis of going after X. I mean, it's crazy. How can anyone think this doesn't greatly tarnish the reputation of our judiciary? It's humiliating. It's humiliating. It really is. As an officer of the court, I find it personally humiliating that this is the portrayal of our justice system across the globe. The justice system that I practice in. It's embarrassing. It really is. It's embarrassing.
Democrat Arthur Engeron? What other reason could there be for hobo judge Engeron to issue a gag order?
I wouldn't call him that. I'm simply saying, like, the way he's handled himself in this case is, to my mind, grossly, it's inappropriate. It's really inappropriate.
And President Trump and President Trump's attorneys once this evidence emerged.
Breaking in just the last hour, the judge in the case has issued an expanded gag order, ruling that Trump's attorneys can no longer make any public statements in or out of court about communications between the judge, that's Judge Engeron, and his staff.
Greenfield is exerting influence.
All right, so let's get back to the oh, I went go back this way. What page was I on here? It's like, there it was. Gonna be here a while. That reminds me. Let me just take care of something real quick here. Let's see if I can redirect to myself. Oh, yeah. Hold on a second. Let me see something. I'm trying to see if I can redirect my audience. On my Trump trial channel, I have roughly 1,200 hours of views, and I need to get to 4,000. I'm punching my way through there. What I realized is I can redirect my stream over there because I plan on wrapping here at midnight my time, but I'm definitely going to be running longer. So when I wrap up over here, I'm going to redirect all of you over to my Trump trial channel. That's good logic. I don't want good logic. What can I get? That's not good. I'm redirecting to the same spot. Why is it not working? I can't redirect to myself. Why is that not working? I'll try it this way. Try it this way. I have given privileges. That I definitely have done. I apologize. Having a little issue here. Definitely giving privileges to myself. Copyrights. Earn customization. Settings. Permissions. Community. All right, let's see if that works now. Un momento. Got it. All right. We're good. Sorry. I just want to make sure you all end up with me when I shut down here. Despite that warning, the next morning, October 3rd, Mr. Trump posted a personally identified and inappropriate remark about Supreme Court principal law clerk on True Social. Copy of Trump's True Social post is attached as Exhibit 1. In the post, Trump asserted that was disgraceful that she was running this case against me. The same post, he reposted a photograph of the principal law clerk. And he didn't even make it a meme, so shame on him for that. And U.S. Senator Charles Schumer, taken an April 2022 event, claimed that she was Schumer's girlfriend. Through his presidential campaign, Trump emailed the post to millions of recipients. Okay. All right. That's not even... I mean, you know, Engoron and his witch are wilder than a lot of third world judges I've dealt with, and that includes the one with dwarfism. Streetwalker permanently under his... He did not. Stop it. Stop it. He boasted to the news cameras outside the courtroom. You saw what she just said about... You saw what was just put out about Schumer and the principal clerk.
I don't have to, because this trial is a rigged trial. It's a fraudulent trial. The Attorney General is a fraud, and we have to expose her as that. You see what's going on? It's a rigged deal. So frankly, You saw what was just put out about Schumer and the principal clerk. That is disgraceful.
That's not even anything wrong with saying that. That's not even wrong to say. I don't understand. I don't even get it. This is crazy. It's pretty crazy. That afternoon, the Supreme Court issued an off-the-record order forbidding all parties from posting, emailing, or speaking publicly about any members of the court staff. As the court explained, Trump's statements about the principal law clerk were disparaging, untrue, and personally identifying. It's not really doxing. It's not like she's easily findable. It's not like it's not like he gave her home address. Court further explained that such personal attacks on members of the court staff were unacceptable, inappropriate. Well, those other things that are going on here that are unacceptable and inappropriate. That's Trump's point. Court explicitly warned the parties that violations of the October 3rd order would result in serious sanctions. At the time, Trump represented to the court that he would not engage in similar conduct again. October 26th, Supreme Court entered a so-ordered transcript containing the October 3rd order. Supreme Court issues its October 2026 sanction orders. Supreme Court during the next few weeks addressed two instances where Trump violated the October 3rd order. First, despite the order, Trump failed to remove the offending True Social. You have to remove it now? Was there anything saying he has to remove it? About the law clerk from his campaign website for 17 days. As a result, the post remained viewable to millions of people. This is crazy. This is like, it's astonishing. You know what's frustrating to me? What's frustrating to me is I think that this actually sounds compelling to anyone who isn't like squarely in their own camp. That someone neutral be like, okay, I don't know. Maybe I'm just, I don't know. Maybe I'm too much of an absolutist. Supreme Court offered petition an opportunity to explain on the record their ongoing publication of the Truth Social post, informing them that on October 19th, they should prepare to address the matter the next day in court. I expect you to be in my office first thing in the morning tomorrow. An email from the Supreme Court petitioners counsel were thus able to consult regarding how Mr. Trump's presidential campaign posted the website statements and to present that information to the court. On October 20th, Supreme Court issued a sanctions order that required Trump to pay a nominal fine of $5,000 for violating the October 3rd order. Court warned of dangers of allowing the post to remain published on Mr. Trump's campaign website, explaining that in the current overheated climate, incendiary untruths can, and in some cases already have, led to serious physical harm and worse. Really? When have they? When has anything he's posted been something that's been incendiary that's led to actual physical harm? I want to know. I mean, I guess they're going to claim that January 6th is probably what they would respond. But I think that's kind of a weird take as well. Court also rejected Mr. Trump's argument that their continued publication of True Social posts resulted from only the campaign structure. I mean, he said, it's not me, it's the campaign people doing this. Petitioners' counsel identified no person ultimately responsible for Trump's presidential campaign other than Mr. Trump. And Mr. Trump did not dispute that the violation resulted from the actions of his employees or agents. Meaning, even if it wasn't him personally, they were under his care. Second, despite they were under his jurisdiction. Second, despite multiple warnings in the first sanction, Trump violated the October 3rd order yet again. October 25th, during a break from the trial, Trump announced to news cameras outside the room, "This judge is very partisan. This judge, very partisan judge, with a person very partisan sitting alongside of him, perhaps even much more partisan than he is." So this is so stupid. It's so stupid. Like, they don't dispute what part of that is untrue. What part of the fact that she's partisan is untrue? And even if it was untrue, he should be allowed to say it. What part of that is untrue? It's astonishing to me. She's a Democrat who supported Letitia James, who, while she was running on a campaign of, I'm going to go after Trump. So what part of this is untrue? It's like their heads are so buried so deep inside their own bodies that they actually think that what they see is what anyone else sees. When parties returned to the courtroom after the break, Supreme Court observed that Trump appeared to have again made disparaging comments about its principal law clerk, and the court reiterated the need to protect its staff in this overheated environment. You're the ones who are overheating things. You're the ones who are overheating it. I mean, this is the other thing. This is the one thing I want to point out, like about the gaslighting from the left. They make it as if he's the one who's no, it's their ridiculous attacks on him that are designed to overheat things and basically make him seem like he's some far greater threat than he is. This is why every time they go after him, his poll numbers go up. Because people recognize that all these times he's been saying he's a victim, even people who are not huge Trump supporters start to recognize, hey, he's kind of a victim here. Kind of a victim. You're the ones who are overheating it. It's an overheated environment. It's like you take the fire and just like to crank that sucker all the way up, and then you're like, oh, it's an overheated environment here. Wow, it's really hot in here. Come on. Why is it so overheated? I don't want anybody killed. Oh, that's the real danger here. Court then gave Mr. And this is how they're trying to say balance of equities. That if we don't step all over his First Amendment rights, people will die. That's what's going to happen. If we don't trample his First Amendment rights, people is going to die. That's what they want the court to believe. Can't deny the fact that the First Department, look, they're preaching to an audience which would tend to be naturally receptive to that kind of rhetoric. Court then gave Trump ample opportunity to respond. Example, court confirmed the petitioner's counsel had a chance to confer with Trump. Court provided counsel time to argue that Mr. Trump had been referring to the witness. Maybe you're not talking about the principal law clerk when you said that, about the partisan person sitting next to you. Court held a hearing in which court placed Trump under oath and questioned him about the statement. After listening to Trump, court found not credible his assertion as coming referred to the witness. But this is so stupid. This is so stupid. If it's something that could be interpreted as not being about the clerk, why would you interpret it against him? So dumb. As a result, Supreme Court again sanctioned Trump, this time for $10,000. Court memorialized the ruling in order issued next day. Quite clearly, he was referring once again to my principal law clerk, who sits alongside me on the bench. Why the hell is she sitting alongside you? How do you write this sentence and not feel like a complete and total cuck? That's one of the things I want to know. As the court explained, Trump's language mirrored his prior language on October 3rd when he complained about the principal law clerk up there at the bench who works with the court. The only person who would know that is someone who heard the first comment, so they already know it anyway. So it's not like it's introducing it to new folks all over again. Like this doesn't. You're actually hurting your own argument. The fact that you need that the only people who would understand it are people who heard the first comment only goes to show how innocuous the second comment is. Court further explained that it was implausible that Trump's statement referred to a witness because the witness did not sit alongside the judge. Instead, sat in the witness box. That's ridiculous. October 26th, Trump paid $5,000 and $10,000 fines. Supreme Court issued a November 3rd order to protect the court staff and preserve the orderly administration proceedings. So this is when I was in court that day. This is the day when Trump was on the stand. And after he got off the stand, they said, we need to bring ourselves a motion. We're going to need to bring ourselves a motion here. Going to have to be a motion. And around the time of second sanction order, petitioner's counsel again began making unprofessional comments about, and that's when we heard the whole "don't do it," Chris. Made repeated comments about where the principal law clerk sits in the courtroom, taking issue with her sitting near the judge. No, not near the judge. Right next to the judge. Right next. We've all seen the pictures. Counsel similarly made repeated comments, principal law clerk passing notes to the judge during the trial because it's weird. And if you think there's nothing wrong with it, why are you embarrassed about him saying it? Right? If there's nothing wrong with it, why would you care? If he wrote instead, principal law clerk is doing research for the judge, would you think that's something wrong with that? Would that be something he should be punished for? Obviously not. That's part of her job. Well, if it's really part of her job to pass notes to him during trial, why is there anything wrong with Trump commenting on it? Oh. That's all I could say was, oh. For instance, I think I've said that I think I've sung that line so many times. I wonder if anyone actually knows what that line is from. For instance, petitioner's counsel, Trump's attorneys insisted the law secretary is writing notes advocating to the court. Yeah. So is there something wrong with it or not? It's really that simple. It's either totally fine or it's wrong. And if it's totally fine, why do you have a problem with him talking about it or her talking about it? And if it's not totally fine, then why the heck is it happening? You're not denying that it's happening. It's so weird to me that they don't even realize how stupid this argument sounds. For concern such as announcing the trial, I'll wait again to get the note from the clerk because the court may have a question based on that note or because the note might instead just be about dinner. Oh, Alina, dropping the fire from the sky. Oh my gosh, it's raining fire from Alina. Oh no, she's raining fire on the court. Raining the fire, brimstone, hail it on down. Lisa said that to the court. I'll wait. She sees him writing a note. I'll wait again to get the note from the clerk because the court may have a question. The court may have a question, meaning she got a question that now the court has based on that note, or because the note might instead just be about dinner. Oh. Counsel openly accused the court of co-judging with its principal law clerk. It's like, how do they not realize how insane? How does he not write this and recognize this really is a crazy situation here that we're asking the appellate department to basically give its blessing to? It's a really crazy situation. On November 2nd, Supreme Court cautioned petitioner's counsel stop referring to its staff, and the court was considering expanding the October 2 order to cover counsel. Court explained to counsel, principal law clerk is a civil servant whose job is to assist the court in processing and deciding cases. Deciding cases? That's a weird way of phrasing it. Indeed, the court explained judges have a right to receive advice from their law clerks. On November 3rd, petitioner's counsel continued to insist on discussing the principal law clerk's role at trial. How did they not realize that this really seems crazy? Counsel suggested that her passing notes to judge somehow injected possible bias into the trial. Somehow injected possible bias. But the court explained to counsel this was part of its unfettered right to get advice from the principal law clerk or assistant law clerk. So essentially, what I'm getting from this opposition is, no, basically our defense is that everything that he did is totally fine. That's essentially what this opposition is. You got any justification for that? The court noted that it was a shame that counsel in attacking the principal law clerk had descended to this level. It's a shame that you can't sit there as a judge on your own 2 feet. You need like little GF walking legs for you, carrying your body around for you, click-clacking in your rundown pumps. Later that day, Supreme Court issued an order prohibiting all counsel from making public statements in or out of the court that refer to any confidential communications in any form between the court and staff. Court observed that it had initially imposed the October 2 order only on only the parties because it had been operating under the assumption that such a gag order would be unnecessary about attorneys who are officers of the court. However, the court explained petitioner's counsel had made repeated inappropriate remarks by the court's principal law clerk, including making long speeches alleging that it's improper for a judge to consult with the law clerk during proceedings. It is grossly improper. It is really grossly improper. I'm telling you, you don't see this happening. You don't see this. I don't see this happening. I'm going to basically right now. I want to pause for just a moment because I am a New York litigator. I practiced in 100 different New York courtrooms, and I'm telling you right now, I never seen this. I never seen a judge do this. And by and large, with rare exception, and some would say that exceptions are what prove the rule. With rare exception, most judges in New York that I have had the pleasure or displeasure of appearing in front of, I have found, for the most part, seem to try to be fair and reasonable and apply the law. And I mean that sincerely. I'm not simply saying that because I'm an officer of the court. For the most part, I have. That's what I've witnessed. Now, the area of law that I practice in is civil litigation. It's not like I'm engaging in political issues. I'm not dealing in civil rights issues or things of that nature. By and large, have I seen occasional exceptions which have been frustrated? That to me, I felt frustrated by? Yes. But to me, those are the exceptions. By and large, most judges that I've appeared in front of, I've litigated in front of New York, I felt have seemed like they're trying to apply the law properly and without bias. I really mean that. This is why it's embarrassing. That's why I'm embarrassed. Because I don't think that what we've seen here is representative of what New York justice tends to be about. I don't think it's been a good display. I think it's been very ugly. The court explained the petitioner's arguments had no basis because well-established judgment consult with court personnel's function is to aid the judge carrying out the judge's adjudicative responsibility. There's a difference between aid and doing it for you. Aid means looking up the law, not telling you what questions to ask. I mean, it's ridiculous. Court explained petitioner's counsel had already had ample opportunity to make their record, and they have at length at their objections the principal law clerk role were preserved. Yeah, well, court underscored that its order was to protect the safety of its staff. And so that's the thing. So if I can't talk about the issues that I have with the inappropriateness of the way that justice is being administered here, that itself is a problem. That is not a proper application of law. Certainly counsel. Are you afraid that, like, are there millions of followers that Alina Habba has? Ridiculous. Supreme Court declined to sign petitioner's proposed order to show cause. November 15th, petitioners present an order to show cause to Supreme Court. On November 17th, Supreme Court declined to sign the proposed order to show cause and provide an accompanying decision that explained its reasoning. Copy of that declined order to show cause attached as Exhibit 3. In particular, the court explained petitioner's arguments were utterly without merit and there was absolutely no co-judging at play. The court again explained the court has a right to consult its law clerks and emphasized the principal law clerk does not make rulings or issue orders. I do. Well, it doesn't look that way. The interim stay and subsequent events on November 15th, they filed the instant Article 78 petition in this court challenging the Supreme Court's October 3rd and November 3rd orders as unconstitutional in the First Amendment. On November 16th, a single justice of the court granted an interim stay of those orders. So this is what, okay, so let me explain. I didn't get up to this part. An interim stay, so there's a process that's happening here. There's a process that's happening. There's multiple windows of time that I want to explain to you what happens here. Okay. First, there's a gag that's ordered. Trump's attorneys go running to court, appellate court. Well, first they go running to court saying, we got a problem with this. We want to follow an order to show cause. Judge says, bam, get out of here. I'm not signing your order to show cause. Order to show cause is the process for saying we want to be heard by the court. The judge says, I'm not even going to listen to you. I'm not even listening to you, which happens sometimes. It's not impossible for that to happen. In all my years of practicing, that happened once. No, it's never happened to me. I had my TRO denied, but the order was not rejected outright. The TRO rejected once, and that was the main thing that I wanted, was the TRO. But anyway, I digress. I don't want to go into my own personal war stories because that's just, I'll be like 20 minutes on. 20 minutes later, I'll come back here. I don't need that. So what happens is you apply for a TRO and a preliminary injunction. These are two different things which are basically the distinction between them under the CPLR is the parameter of time that it's covering. So the gag order is issued, and they go running to court and they say, we can't have this muzzle come on. You can't give it to him. You have to stop it right today, right here, right now. Otherwise, his rights are being trampled on. We need a TRO signed right now. Temporary restraining order signed today. Saying that muzzle doesn't go on him. And we want to come back here before the court sometime in a week, 2 weeks, whatever the date the court decides. And the court's going to tell us how we serve. And we have a whole motion here that supports it. And all the basis for why it is that we need the relief that we're seeking. And all of this, it gets reviewed twice. All those initial papers get reviewed twice. The first time is the day you come in there. There's actually, New York court has set up there an emergency judge who's supposed to handle motions of this sort. Now, they don't sit in an emergency courtroom thing. The way they actually have it structured is that, like, there's one judge at all times. There's a judge who's assigned to oversee this stuff. So they take turns as to rotating as to who the judge is that's overseeing emergency applications. Someone's got to go running in there on theoretically, I never had to do this on a weekend, but like someone comes running in there and says, I need to handle this. Well, you need to be able to go in front of a judge right now. So it's basically a judge is automatically thrust to you. Now, you might have to wait a half hour, 45 minutes, an hour, 2 hours. But within a couple of hours, you'll be arguing your motion in front of a judge. And you say, I need this relief immediately. Today. Has to be signed. Sign this order, please. And they'll look through your papers. And if you meet all your procedural elements, and under the law, it seems like you're entitled to the relief, they will issue a temporary restraining order or an injunction. How long does that last? They will also say, they'll say the relief that they're seeking, that blah, blah. So in this case, it says the gag order that was issued by Judge, the muzzle that was ordered by Judge Engeron, stayed. How long? Under this temporary restraining order, we're restraining the muzzle, the muzzle, which is the gag order. So we're restraining the muzzle today. How long does this restraint that's stopping it? How long does this restraint last? It lasts 2 weeks, or it lasts until we come back in here and the judge has a chance to really argue in front of both sides. Why do they do it like this in New York? The reason they do this is because I come in, I'm begging for relief from the courts. We believe in the judge being able to hear both sides. So I have to provide notice to the other side, tell them I'm going to be going to court at 11 a.m. Tuesday, November 28th, and arguing, and I'm going to be seeking this relief. And I'm supposed to give them really 24 hours notice. And in my papers, I got to say, I gave this notice to them so that they know I'm here today. I gave them this notice, and they know that they wanted to fight against me and argue against me and against you signing this thing today, that they should get their tuchses down here so they should argue against it. Now, even if they show up there, which frequently the other side will show up, more often than not, they will show up. They didn't have a chance to read your papers. But before you got in there, you just finished writing those papers often an hour before you got to court. So they didn't have a chance to read anything, research anything, provide any opposite case law. They're just sitting there arguing off the cuff against you. So now, the judge looks at your papers and says, well, when I look at these papers, it looks to me like these papers, they have all the elements to get the temporary relief. It's got the 3 elements. It's got the likelihood of success in the merits, and balancing of equities favors the movement, and you have your irreparable harm. So I'm inclined to give this relief, but I want to hear from the other side. Do you have any argument why I should not be giving this relief? And they'll have this little exchange, oral argument on the spot in front of this judge. And if the judge agrees with the movement, the party that's seeking to get the temporary restraining order, they'll sign off on it. And it'll say, it is hereby ordered that this gag is not going into effect pending a further hearing on this. So meaning until such time as we come back, that's how long my temporary restraining order lasts. And at that point, it dies. And the muzzle would come back in. So in this case, they went into court on the 15th, and the judge says, okay, there's no gag on until we come back in here on November 27th. And we actually have a chance to be heard in front. And actually, what happens in between? Well, the party opposing the relief has a chance to look at the papers, research, put together their own papers, explain why they're right on the law, and put together like this thing that we've been reading right here from Attorney Fan. So he's basically explaining why it is that no, the relief they're seeking, they're not entitled to, and then present that to the court. Sometimes there'll be an opportunity for reply, not always. It depends on the time parameters and up to the judge who's signing. And the judge puts in the order, you're going to appear back in here before me on November 27th. And they also tell you how you need to serve papers on the other side. All this is written in the TRO. So this TRO, it's called a stay. That lasts until the return date, which in this case was November 27th. After that, normally what would happen today is they would decide today. They would have oral argument decided today. I didn't see that in order what's decided today. Normally, what happens at that point is that gets changed over if you win and you convince the court that you're entitled to this TRO relief, this injunctive relief, that becomes a preliminary injunction. So it starts as a TRO, and they're likely to give it to you if you have all the merits and the other side can't give a crazy reason why it's be disastrous to give you the TRO. They tend, if you know what you're doing as a litigator, you're likely to get that TRO. Like I said, only once in my life did I ever not get a TRO. And the reason I didn't get it in that case is the judge was afraid that if he gave me the relief that I was asking for, that a bunch of old people would die, which was ridiculous and not true. But that fear that people would die is why he said, I'm not going to take that chance. And I'm like, they don't even know what, the other side put up arguments, they don't even know what they were talking about. There's no one whose life is in danger in any way, shape, or form. There's no way anyone, it's all ridiculous. It's like, yeah, I'm not going to sign this. So, but that's for another day. I think I've told that story here. I'm not sure. But anyway, bottom line is, so the first judge is the emergency judge of the day. And they sign the TRO. Then you come back to the court and you argue in front of like the panel there, or whichever judge is assigned to it, and that's when you ask for your relief. When you ask for your relief at that point, you're basically saying, let this be a preliminary injunction. Now, it works a little differently in appellate court. In appellate court, they don't always have oral argument, so it just becomes like a return date. So, and the nature of the wording of the TRO might be until such time as a decision is issued by this court. In fact, that's likely the language that was issued. Yeah, let me see if there's is this it? No. I want to see if I can find a copy of the order. Shouldn't be the first filing. Exhibits. Here's the order. That's what I was looking for. So here's where you see the language of the order, which says interim stay of enforcement of 2 unconstitutional gag orders and imposition of sanctions thereunder, pending a full panel determination of Article 78 petition of mandamus prohibition. So this is what we're getting into here. So what this means is interim, meaning for now, with a stopgap, we're going to stay the enforcement, meaning stay that gag. We're going to stop that gag. Stay it means we're going to hold it back. The enforcement of these 2 unconstitutional. It's an application for to stay that 2 gag orders and imposition of sanctions. And if yes, Supreme Court's gag orders entered during the non-jury trial in the underlying proceeding. Attorney for movement. And papers served personally, court attorney. Here's the signature of the judge over here, Justice DF. This would be the first department judge, which I don't know. Who is this? Can I put a name on? They don't put the name of this judge on here. But this is not Engeron. This is the First Department judge. Considering the constitutional and statutory rights at issue, an interim stay is granted. This was written by the judge. This handwriting over here, this is the judge wrote this. This is the First Department judge wrote. When they applied on November 15th, so the judge said, considering the constitutional and statutory rights at issue, an interim stay is granted. What was the nature of the stay? This part was typed out by Trump's attorneys, where he's basically saying, we want to stay on the gag orders that were entered during the non-jury trial and the underlying proceeding and unconstitutional sanctions. So now, when this opposition is coming in here, and the opposition has to be filed by November 22nd, so we look at this opposition here. So they're saying is a single justice of this court, meaning the appellate court, granted an interim stay of these orders while the court resolves petitioner's motion. Since this court granted an interim stay, Trump has engaged in a number of meaning Trump is not under the gag order right now because a judge issued a stay. You know what he's been doing since you lifted that, since you gave him that stay? You know how he's abused that privileges? He's issued personal attacks against Supreme Court principal law clerk on Truth Social. On November 16th, he posted the court's politically biased and out of control Trump-hating clerk who is sinking him and his court to new levels of low is a disgrace. 2 days later, he posted an online article suggesting the principal law clerk engaged in drug use. He did? They attach Exhibit 3 here. There's Exhibit 3. La 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 la. It's very hard to find things in here. See, one of the difficult things about the way this is normally. Right, this is a judge committed fraud in my trial by valuing my assets in a tiny fraction of what they're really worth. Everyone, including his crooked and highly partisan law clerk Allison Greenfield and racist AG Letitia James, knows it. Judicial system is New York State is in chaos. Disrepute over his horribly handled prosecution. World is watching this illegal witch hunt. Engeron, James, and Greenfield to be sanctioned and prosecuted over this complete and very obvious case of justice. I don't see where he talks about drug use. I don't know what they're talking about. That was supposed to be on the 18th. All right. So, moving along here. Let me cover a few of these here. With not that, but yeah. Oh, he said, as which are wilder than a lot of third world judges I dealt with, and which includes one with that dwarfism. Hope everything is well with you and your family. Much love. Thank you, USSS. I appreciate that. Reply letter is much better. Well, I want to go through the reply letter. So, this is what they put in their opposition. And then they start making their arguments here. So, what are their arguments? How many pages are you going to get to? 12? Oh, God. 30? Another 20 pages of this? Lord. I'm an hour and a half in. Another 20 pages of this. So, their arguments boil down. Yeah, make it a little bigger here. Scrolling back up to their arguments. So they say that Article 78 is unavailable to challenge the Supreme Court order. So they try first arguing on procedural bases. They say that in Article 78 cannot be used to challenge determination that can be adequately reviewed by appeal to a court or some other body or officer. Okay. Supreme Court's orders were issued without motion practice during a civil case. Petitioners can file a motion to vacate those orders and appeal from denial of the motion to obtain an appeal. It is strange to use an Article 78 rather than a normal appeal. I'm not going to kid you. I'd be curious to ask Alina that question. Then they say petitioners incorrectly claim that Article 78 is available to review the October 3rd, November 3rd orders that restricted their statements regarding Supreme Court staff. Petitioners rely on Article 78 challenges to gag orders that arose in criminal cases, but the underlying case here is civil rather than criminal. So that distinguish matters because the court has only granted Article 78 relief vacating gag orders preventing counsel from speaking with the press in the course of criminal prosecutions, where immediate review is presumably needed to protect the criminal defendant's constitutional jury trial rights. No such concerns are at issue in this civil bench trial. So we need to have a greater concern for defendants' rights to speak if it's a criminal case. Is that philosophically logical? Perhaps. Certainly, that seems like a more perilous situation if it's a criminal trial than if it's a civil trial. I think we all would agree with that. So when a person's facing that kind of jeopardy, maybe we should be that much more careful about silencing them. I'm going to give him a fair point on this one. I think that's a fair point. If it's accurate, that doesn't apply in civil. Petitioners also err in arguing that the October 2026 sanction orders are reviewable under Article 78 because these orders are summarily punishing contempt committed in the presence of the court. The Supreme Court imposed sanctions for frivolous conduct to not hold Mr. Trump in contempt. So they want to say that because it's not in contempt, Court of Appeals, as indeed held, those challenging a sanctions order entered without motions practice must instead proceed first moving to vacate the order, then appealing from a denial of that motion. So what they're saying is they couldn't come to the appellate court. First, they had to apply to him. Now, I know that they applied to him via order show cause, but that application seemed to be not about the gag order as much as it was a motion to dismiss. Court should deny petitioners' request to stay the October 3rd, November 3rd orders prohibiting statements regarding Supreme Court staff. Petitioners have no likelihood of success in the merits because the orders are constitutional. So the first argument they make is procedural problem. This should not be Article 78. Second argument they make is that the orders are completely constitutional. Neither the First Amendment of the U.S. Constitution nor Article 1, Section 8 of the New York Constitution prohibit trial courts from restricting speech of trial participants if it threatens the safety of the court staff or frustrates the orderly progression of an ongoing trial. How is this frustrating the orderly progression of an ongoing trial? Here's the double-edged sword. But let's hear their argument, and then I'll respond to what they say. To the contrary, courts have the power to impose reasonable restrictions on both litigants and their attorneys during ongoing proceedings when necessary to safeguard it. So it's well established that, although litigants do not surrender their First Amendment rights to the courthouse door, those rights may be subordinated to other interests. It's important to remember that reasonable limitations may be placed on speech where an important countervailing interest is being served. Okay. So courts have and they go even further, saying that courts have an affirmative duty to actually monitor people's speech if it's protecting people. In light of these important considerations present during the ongoing litigation, the Supreme Court and federal courts of appeals have recognized the distinction between participants in litigation and strangers to it, pursuant to which gag orders and trial participants are evaluated under a less stringent standard than gag orders on the press. A more stringent standard is required for restraint on the press because the unique role the press plays in the public's eyes and ears in the judicial system. Unlike trial participants, the press guards against the miscarriage of justice by subjecting the police, prosecutors, and judicial processes to extensive public scrutiny and criticism. The Supreme Court has therefore been unwilling to place any direct limitations on the freedom traditionally exercised by news media. So it's saying that we need to give a broader power to the press and be much more careful about gagging the press than we would have to be with trial participants who don't play the same role. So both federal court and New York courts recognize the tests which must be applied in these cases involve prior restraints on publication are stricter than the tests which may be applied to prior restraints upon attorneys, parties, jurors, and court personnel. So saying we have leeway here, much more leeway than Trump wants to claim. Accordingly, while restraints imposed by the trial court on the press or other non-trial participants bear a heavy presumption of constitutional invalidity, that they're no good, which may only be overcome upon showing clear and present danger, serious threat to the administration of justice. That rule doesn't apply to trial participants like Trump or the attorneys. Instead, as it relates to free speech rights of litigants or their attorneys outside the courtroom, prior restraints may be imposed on a showing of necessity for such restraint and determination that less restrictive alternatives are unavailable. The necessity for prior restraint on trial participants can be established upon a showing a reasonable likelihood of a serious and imminent threat to the administration of justice. Well, how is it an imminent threat to the administration of justice? That's the question. It's not a jury trial. If it's not a jury trial, how is there a threat to the administration of justice? Are you afraid that Judge Engoron, if he gets nasty emails, is not going to be able to administer justice? Is that what your claim is? They were saying, they're trying to play both sides of this issue. The fact that it's a bench trial. They're like, well, it's a bench trial, so why does he need to speak to the public? It's not like he needs the public to hear his position. If it was to the public, they'd say he's jury tampering. He's tainting the potential jury pool. So it's like, we have a right to silence you no matter what, according to the government, I guess. Disgraceful. I mean, we've heard Big Fanny in Georgia screaming, "Oh, why we have to have him gagged? We need him gagged. Jack Smith wants him gagged. Why? Because he's poisoning the potential jury pool." Now, so we're not going to have fair justice. There's one judge here. There's no jury. How is there any harm by him talking to the public? Well, this is actual threat of physical harm. Free speech rights of attorneys inside the courtroom during litigation are even more limited. So attorneys, we can restrict even more. Gag the hell out of us. A trial court has broad authority to control the courtroom, rule on the admission of evidence, elicit and clarify testimony, expedite proceedings, and admonish counsel and witnesses when necessary. Thus, it is unquestionable that the courtroom itself during a judicial proceeding, whatever right to free speech an attorney has, is extremely circumscribed. That's really interesting. They circumscribed the Gentile case. I saw that. Applying these principles, the October 3rd, November 3rd orders, they claim comport with free speech rights. And the court should thus deny the request for a stay. So I'll tell you that on this argument, there's more of a basis to do it, but the key thing that they just sort of rushed right past was upon a showing of necessity for such restraint as an determination that less restrictive alternatives are unavailable. You can't showing necessity for such restraint. How do we establish that there's a necessity for this restraint? How is this established? How is it established there being a showing necessity for any restraint? Then he claims it's properly tailored to protect Supreme Court staff from harassment without undue burden on the party's speech. How can the court get away with this? Well, the Trump's attorneys think that they can't. That's why they're going to the First Department and trying to get relief there. To answer your question. If I'm right, can I get a war horn? I think it's the Weird Al Yankovic song about going through the drive-thru. If I'm wrong, I'll send more money. Oh, oh, oh. And that's all I could say was, oh, there's really one more thing. There's just one more thing that I really think you should know. You can get unlimited refills for just $0.25 more. I said, great, but I'm at a drive-thru, So what would I want that for? That's right. Very well done. Good job, Master Phillips. You got the war horn. Angeles Unbreaded became a YouTube member. Welcome aboard to the following UN cult initiate. The following is not a cult type of cult at all. It's like it was Forbes magazine rated one of the 3 least culty cults in the history of all cultdom. Very not culty type of cult. It's really, I don't even know why people say it's not a cult. It's not at all a cult. Really not at all a cult. Okay. So what they're saying is the Supreme Court's order was especially appropriate because Trump's pattern of similar conduct in other trials where he's defended. For example, so he's got a history here. That's a novel theory that you can use that. In the criminal prosecution, Trump pending U.S. District of D.C. Court imposed a similar order on Trump after he made personally identifying and disparaging statements on social media about individuals involved in those proceedings. Statements pose sufficiently grave threats to the integrity of these proceedings that cannot be addressed by alternative means. Yeah, but they said that you're tainting the potential jury pool. So it's a little different. As the court found, undisputed testimony demonstrates that Trump has publicly attacked individuals. These individuals are consequently threatened and harassed. So this is an interesting philosophical question. And I want you to take off your Trump hat for a second, and let's just think about this for a moment, okay? Let's think about this for a second. Because I do think that I want to try to step outside of my box and really approach things from a moral, philosophical, like let's think through like what's right, okay? I started this evening off by telling you that I'm a free speech absolutist, and that's why I run my chat the way I run my chat. I'm a really big fan of free speech. But what comes up in the reply, which I don't know how deep into the reply I'm going to get. I'm going to try to get as deep into it as I can. What comes up in the reply is a very interesting question, which is, they say the ramifications of what people do with his speech is not something that you can be held against Trump. So even if people are harassing because of things he says, they don't really, if we accept that as a given, is there a moral basis to say your speech is not like anyone else's speech? And I'm going to give you, and I know that 95% of you properly are going to start with like, get the hell out of here, Joe. That's what you should have screamed at already. Or shut the heck up, Joe. That's what you should have screamed already. If you didn't, shame on you. Because, yeah, what the heck does that even mean? We have Congress cannot infringe on our First Amendment. The government cannot infringe on our First Amendment rights. So freedom of speech is an area that no court, no law, nothing should be able to abrogate. And yet we know that there's certain circumstances that we accept that abrogation. For example, we don't allow incitement. We don't allow conspiracy, right? We can have you held civilly liable for damages if you defame someone. So when we say that you can't pass any law that's going to be infringing on free speech, that doesn't mean that your First Amendment rights make you free from any sort of punishment. And these are accepted basic principles of First Amendment. So the question I really want to just think about this for a second, okay? If we know that this person, take Trump out of it. Let's just fast forward. Okay? 100 years in the future. 100 years in the future. Okay? Our great-grandchildren, your great-grandchildren, my great-grandchildren are sitting here dealing with an issue of the day. And the issue of the day is that there is a person who he basically has advocated. I'm not talking about Trump. Not it's. I'm just trying. I'm going to draw an extreme hypothetical here to test the philosophy that the impact of someone's words and how it's going to be taken should never be factored into determining their freedoms, their rights of freedom of speech. Which is where I start, where you likely start. So I'm sort of testing my own brain. And I don't want it to be with Donald. So let's assume that there's a political leader. Let's assume it's a political leader on the left. Okay? Just because I assume that most of you are sitting on the right. There's a political leader on the left who's terribly popular 100 years from now. You're going to be dead by then. But your great-grandchildren are living then. And there's a political leader on the left. And that basically he becomes crazy popular. And I can't explain how this happens. You can't really understand it happens. But it seems very natural 100 years from now that whenever he has that whenever he gives a person's name and address, doesn't say anything else. Whenever he says a person's name followed by his address, his crazy, rabid, frothing fans go storming over to that person's house and kills them. And he has 5 million fans. So whenever he gives someone's name and address, goes on the air and talks in public, and basically he doesn't say anything other than he just says John Smith, 19 Ogden Lane, Birmingham, Alabama. And that's all he has to say. But he's so popular, and everyone figures they understand what it is. Even if he's just like talking and he's having this whole nice conversation about a baseball game that he saw. But then every time he does something like that, John Smith, 19 Ogden Lane, Birmingham, Alabama, we know, and it's happened 100 times before, 1,000 times before, that every time that happens, every time he does that, that person is dead within 24 hours, lynched by thousands of people. So would we say that person, would we think that person, and we also think, there's a reason, and there's a long history of practice that basically anyone who's a political rival to him and the greatest speakers on the right, that's the ones that he tends to target. He calls them out, John Smith, and all of a sudden, boom, they go running and they lynch him. This is obviously a crazy extreme example, but my point is that I think that we can understand that conceptually, arguably. And if you disagree with me, drop me a comment. And if you're watching afterwards, drop a comment down below. Tell me what your thoughts are. That conceptually, yeah, we need to do something about this speech here. I mean, you can understand people, at the very least, even if you don't think that we should do something about it because you're afraid of the abuses, if we start going down that path, I can understand that. But I think you could also understand that if some people were like, yeah, we need to do something about this, then you'd be like, yeah, I get that. I get that. You might not come to that conclusion yourself, okay? But if Shaniqua Ray Smith has this massive following 100 years from now of tens of millions of followers, and every time Shaniqua says the name and address of someone that person is dead within 24 hours, killed by thousands of people. And it's happened several hundred times. I think at a certain point we'd be like, right, we really need to do something about this whole Shaniqua thing, this whole Shaniqua with her address thing, right? I think you can understand people coming to that conclusion. So if in that extreme case you can understand it, so in that case, where is that at all like what's happening now with Donald Trump? Absolutely not. Obviously not. Obviously not. And you might not even come to the place where you say in the Shaniqua situation that you agree with limiting Shaniqua's speech 100 years from now. And if she's one by one offing your own great-grandchildren 100 years from now, you'd be like, yeah, that's the way it goes. Free speech. You might feel that way. But you can understand that others wouldn't feel that way. So the question is, where, and I know that's a much crazier situation, much crazier than anything the left could even pretend to claim about Donald Trump, and the impact that his words have on harming or affecting other people. But I think if you recognize that there's a difference between these two, then I think you need to explain in your own mind for yourself, what is the distinction? Is it the pattern? What makes there a distinction as to why you would say it's justifiable to try and silence Shaniqua from giving out a name and address compared to silencing Donald Trump from offering disparaging comments about some individual? Is it the death factor? Is it the history? Is it the, it's the established pattern that Shaniqua has that's definitely not at all established with Donald Trump? The reason I'm having this exercise because I want you to sort of think about for yourself. Like, step out of anything that I'm going to tell you or try and convince you of, or anyone else going to try and convince you of, and just sort of think to yourself like what you understand, what you feel in your heart is fair and just for how we approach our perspectives on free speech. Because when you go through that exercise, then you can better apply it and think, okay, why do I feel this way? Am I being governed because I like this person? Or am I being governed because I dislike this person? And how much is that affecting the rational part as far as philosophically, what is a healthy society? That's why I wanted to pause and have this sort of conversation with you to give you a chance to at least flesh that out in your own brain. And with that, we'll continue. And look at the reply. Hey, the Gentiles in the country took a lesson and we can circumscribe with the best. Can you now? Can you? I don't like having this thing here. Let me pull a document list here from the reply this way. This will be better. That's better. All right. Albuquerque was my jam back in the day. That was the Albuquerque. Wait, that's from Weird Al? Is that what you were talking about? So the future FBI is still working for the left. I was just trying to give some sort. I wanted you guys to sort of think through what I was saying there because I think it's an interesting. I think it's an interesting like sort of question. This is the baby. Oh, Adolf question with free speech, or is it something else? No, it's really something else. It's designed to help you understand your own perspectives as to why free speech should be protected, or if there's ever a place, if there's ever a situation that we should say that free speech needs to be abrogated because the impact that it's having on followers. That this is just crazy. This is just like, they can just kill whoever they want. Like at a certain point, should we not think that there's something, that there's a limit to free speech? That's really the question. That's really the question. Alex Jones is blamed for people harassing the Sandy Hook parents. Yeah, and I think that was wrong. I think that was wrong. Clifford S. Robert, an attorney duly made practice law for the courts in the state of New York, hereby affirms the following statements to be true and penalty of perjury. I'm an attorney, practice law. That's why I'm signing an affirmation, not an affidavit. This affirmation is submitted in further support. Petitioner Donald J. Trump. Subsequent to the filing of the verified joint Article 78 petition, respondent Honorable Arthur F. Engoron entered an order declining to sign petitioner's proposed order show cause for mistrial. So he didn't even let us come forward and argue for a mistrial. Here's Exhibit B. Is a letter submitted by respondents, people of the state of New York by Letitia James, wherein the AG stated its position that Engoron should sign petitioner's proposed order to show cause, inasmuch as the Attorney General deemed it preferable for petitioner's motion for mistrial to be heard and decided on full briefing. Meaning, even Letitia James said, why are you not letting them be heard? Let them be heard and then reject them. It's ridiculous to not let them be heard. Like I said, I've never seen that. I have no idea how many orders to show cause, and I've never heard of them saying, no, you can't come to court. It's weird. It's really weird. Especially after the judge said, the only way you can allow me to file this motion is by order to show cause. It's almost like from the get-go, he's like, I'm never going to let you be heard. Even that, I mean, this is just, it's astonishing. Annexed here, too, as Exhibit C is the order issued by Judge Engoron. All right. What? That's it? No, that can't be it. Well, the memorandum of law. This is what I was looking for. Why didn't I see that in the filing? This should have been in the filing here. Here's the filings. It must be later in here. It must be later here. Is it order to show cause? Here it is, memorandum of law. This is from today, right? This is November 27th. This is November 15th. This is not the order. This is not the memo of law. I want the one from today. La 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 la. I guess we're going with this one. It is what it is. All right, you got your table of authorities. And here we go. Preliminary statement is giving an overview of everything here. We're going to skip past that and move on, ease on down the road. What I'm going to do is this. I want to get into the reply, but I do want to, in 15 minutes or so, I'm going to shove us all on over to Trump Trial channel. So, in fact, what I'm going to do is this. I'm going to put a link. Let me put a link. Let me give you a link. Copy. No, that's not what I want. Come here. Now, I redirected you all. This is not going to affect anyone in Rumble. You guys in Rumble, nothing's going to look any different for you. So this is not going to affect anyone. You don't need to think about that. But this will affect those of you who are on YouTube. I'm putting the link in here for my Trump trial where I'm streaming the exact same thing at the exact same time. And I'm going to put this in the description also. What is this? Oh my gosh, this stupid heart thing, man. All right, I'm going to pin that message. I'm going to put it in my vid on Trump trial channel. And I've already redirected, so you really should end up like right there, even without clicking it. But in case you don't, In case that doesn't work for one reason or another, the redirect doesn't work. It's going to be in 15 minutes. I'm going to shut down on Good Logic, and I'm going to keep streaming on Trump Trial. Okay. No threat of physical violence by speaker. The actions of another should be pushed onto the speaker. We can't control what others do. Oh, I'm totally on board with you. I'm totally on board with you. I think that the whole argument is ridiculous. I'm totally agreeing with Alina Habba. I agree with all of you who think that this is a pretty brutal misapplication of the law. That's my personal perspective. My question is there ever a limit to that, though? There has to be. I mean, there obviously is a limit. The question is, so how do we come to determination on what the basis for that limit is? And the other thing I'll throw at you is this thought. Maybe if people are if they were really mindless and trained to act violently, so you had dominion and control over them, then I think that would be a basis for a distinction. But no one could make a good faith claim of that nature when it comes to MAGA. All right. Petitioners move for a stay of further enforcement of the gag orders in an attempt to redress Judge Engoron's brazen and unmitigated violations of the Constitution, New York State Constitution, judiciary law, and rules of this court. It's a mockery of law. Brazen. Don't get brazen with me. Notion that an openly and overtly partisan individual would have any role in decision-making process in this unprecedented case runs squarely counter to the foundational principles of American judicial independence and the constitutional guarantee of a fair trial. You rant it. Go rant it. What's this guy's name? Who did this? What's this guy's name? Ray? Is that his name? Ray? Robert Ray? Clifford Robert. You go, Cliff. You go, Cliff. It's your birthday. You go, Cliff. I like opening the preliminary statement with something powerful like this. Indeed, this is precisely why the Code of Judicial Conduct prohibits judges and their staff from engaging in any partisan political activity. This is Exhibit 1. Yet here, the sweeping, unconstitutional gag orders, which restrict both petitioners and their counsel speech, have impermissibly abrogated petitioners' First Amendment rights to demand basic fairness and to highlight publicly the very open, public, and partisan conduct that has infected and permeated the trial. Yeah, you're worried about coming to light. You're worried about coming to light? Why are you doing this stuff that you were so worried is going to come to light? In sum, the gag orders should shield Justice Engoron as openly partisan clerk from the precise scrutiny essential to maintaining public confidence in the judiciary and ensuring a fair trial. I've been screaming that over and over again from the mountaintops. I actually had to do you know how difficult it was? I had to actually go drive out to find a mountain and go up to a mountain and start screaming, Judge Engoron is ruining our New York judiciary! From the mountaintops. The Supreme Court has ignored with impunity clear and troubling evidence of partisan political bias, and so doing undermine perhaps irreparably the rule of law. I really think they have damaged. I think they've really damaged. Respondents now urge this court to inflict petitioners constitutional injury anew by vacating the interim stay and bestowing on Justice Engoron an absolute, unfettered power to punish petitioners for validly objecting to demonstrable partisan bias on the bench. They're just coming after us. They want to keep being able to come after us. At stake is a civil defendant and front-running presidential candidate's ability to critique, without fear of reprisal, the court presiding over a bench trial historic, both by virtue of the parties thereto and the novel manipulations of the executive law. Yeah, that's pretty historic too. Courts should reject respondents' invitation to error and protect the bedrock rights undergirding the legitimacy and integrity of the judicial system. Petitioners' free speech interests are anything but vanishingly slim. Affirmation of Dennis Fan. Petitioners are deep into the second month of a trial that the world is watching, which carries serious implications for the limits of the Attorney General's power and equally grave consequences for petitioners' personal and business interests in this state. Each day, petitioners must defend themselves before a de facto panel comprising Justice Engoron, who already determined President Trump is not credible and levied 2 unlawful contempt sanctions against him, and the unelected principal law clerk, who openly supports and donates to Democratic figures and organizations that have declared President Trump their avowed political enemy. You even put in here, you left out here how she supported Letitia James. Specifically. That if she's sitting on this panel, she would have to recuse herself. If she was a judge, she arguably would have to recuse herself. Instead, she's a de facto judge. De facto means acting in fact, if not in name. Good Latin term. In general, whenever you see a term in legal pleadings that are italicized, they're usually Latin. Almost always. More fundamentally, petitioners' interest in raising the issue of bias on the bench implicate a touchstone of American constitutional framework: the ability to criticize government officials without fear of reprisal. Supreme Court's disapproval or disagreement with petitioner's speech, or the fact that a third party may respond to it in an abhorrent way, meaning just because some third party is going to go off the rails like a lunatic, do not justify putting that principle at risk. Doesn't matter. Doesn't matter if there's some crazy person who might do something stupid that we think is gross. That doesn't matter. If it is to have any meaning, the First Amendment must protect everyone, including petitioners. Moreover, any enforced silence will doubtless engender resentment, suspicion, and contempt much more than it will enhance respect. Meaning, you are spitting on the court if you uphold Judge Engoron's order. The gag orders prohibit petitioners from making any in-court or extrajudicial statements about Justice Engoron's staff, including principal law clerk, regardless of content. You can't say anything. You can't, under the gag order, he cannot even say the name of one of the clerks who works for Judge Engoron is Abby Greenfield, and her hair and Biden thinks her hair smells great. That would be breaching the gag order. Respondents do not, because they cannot rebut petitioners' factual allegations regarding the principal law clerk's public and partisan political activities, open support for Democratic candidates, and causes with demonstrated antipathy toward petitioners, all during the pendency of the underlying action. This is not stuff she was saying 3 years ago at some anti-Trump rally. This is while the case is going on. While it's going on. Contributions well in excess of the sum permitted by the Code of Judicial Conduct, nor do they dispute the principal law clerk sits on the bench with Judge Engoron, has been repeatedly photographed as Judge Engoron's side with his permission, rolls her eyes at remarks by petitioner's counsel, and constantly whispers and passes notes to Judge and Justice Engoron in response to petitioner's counsel while the parties are on the record, which is gross. It's gross. Really, she's worm-tongued. She is worm-tongued. Nonetheless, respondents dismiss all statements about the principal law clerk as vexatious, baseless, and inappropriate because she's a civil servant. Oh, she's just a civil servant permitted to advise Justice Engoron. Given the circumstances, this extraordinary position calls into question both the timing of the gag order and the integrity, vel none, of the trial process. Oh, they mentioned the AG over here, number 3. Many of the organizations the principal law clerk supports have actively supported the Attorney General. Principal law clerks also attended partisan political events while this case was pending, where speakers inter alia openly advocated for Joe Biden and comments on the fight against development and the profits of big real estate and the consequences of the former president, i.e. President Trump. Respondents' perfunctory denomination of such speech as unworthy of this court's consideration fails to overcome all the legal infirmities fatal to the gag orders under the First Amendment. This is fire. This guy, Clifford Roberts, I like his writing style. I really like it. I like it a lot. At the outset, respondents attempt to avoid the merits of petitioners' claims because petitioners could possibly pursue an appeal at some future point falls flat. Ample case law and statutory support confirm that petitioners' challenges to the gag orders and Justice Engoron's rampant abuse of summary contempt power were properly made pursuant to Article 78. So yeah, we might have been able to go through that process that they said, but Article 78 works for us too. Moreover, the suggestion that petitioners' sole recourse for a clear First Amendment violation is to wait months or years for a decision on appeal of a final judgment willfully ignores the irreparable injury inflicted when a civil defendant in a bench trial, who's also the front runner for the Republican presidential nomination, is silenced on a matter of such grave personal and public import. Respondents' sole cognizable justification for the gag orders is that an unknown third party may react in a hostile or offensive manner to petitioner's speech. This should be rejected. Rejected. Kick this garbage out. We don't need it anymore. I'm going to be jumping over right now. I'm going to be shutting down. I gave you the warning before. I think it's time. It's time for me to move over. Time for me to move over. So I'm going to be... Let me see if there's a break here. I got a while still before the break. Okay. I'm going to be moving over and shutting down Good Lawgic. I'm going to be watching this. You're going to be redirected. I'm going to give you like an extra 60 seconds in here for the redirect to happen. But you should be redirected over to my Trump trial channel. So let's try this out. I'm going to be shutting down. If you're on Rumble, stay where you are. Nothing's happening to you. Stop getting all freaky. I don't like when you're getting all freaky. Okay? Stop getting all freaky. Okay? Not getting all freaky. But I'm going to shut down my Good Lawgic channel for now. 3,